Good? Yeah, we're good.
Yeah.
Okay, guys, we'll get started. Okay.
I'm going to let these guys introduce themselves, but we are grateful that they are here to share more about all the legal cover documents that you need and the considerations that you should be thinking about when you are thinking about transferring your farm to the next generation, or to anyone for that matter. So thank y'all for coming, and I'll let y'all introduce yourselves.
Robert McKay, and it's actually fitting that, we'll get some echo, that Jonathan and I are here tonight. We actually met in Tyler's grandfather's office here in Winchester. This is Jonathan. So go ahead, Jonathan.
Great.
Get the echo.
Yeah. My name's Jonathan Burns. I'm a estate planning attorney at Spencer Fane in Nashville. Excited to be here with y'all. Thank y'all for coming. And so to preview for you what we're going to talk about and give you some more detail on tonight, we'll talk about what's the difference in having, we'll call it no plan whatsoever. What happens if you don't do any type of planning at all versus just a basic plan. We'll talk about what's the difference in a will versus a trust and different types of trust options. And we'll also talk about, when you leave things to a child or leave things to an individual, what are ways to do that? What are ways to protect the farm, protect assets and things that they might receive go down the road. So starting with doing nothing, right? Starting with not having a plan whatsoever, okay? So real estate you own, if you're married and own a joint name with a spouse, when you pass, it'll automatically go to the surviving spouse. It doesn't matter if you have any type of plan whatsoever. Just by operation of law, it would go to that surviving spouse. Financial accounts you have that might be in joint name with a spouse or otherwise have what's called a beneficiary designation that say, well, hey, if something happens to me, here's who gets it. That contract will control where that asset goes. So even with no plan, at least it gets where you intended it to go. But for things like real estate, that might just be in your individual name. Okay, if you don't have any plan whatsoever, the state of Tennessee gets to decide, okay, who gets your stuff, right? And who's in charge of that process to get those things transferred to the people who do get to inherit those assets through a process called probate, okay? So there's laws that say, well, hey, if you have no plan, who's going to be in charge of that process, right? Who's got priority to be in charge as the administrator of your estate? Then they also have a statute that says, well, hey, if you decide not to plan yourself while you're living, here's who's going to get your stuff, right? Here's who's going to inherit your assets, okay? Which may be in line with what your intentions would be otherwise, but oftentimes it's not, okay? Oftentimes it's not. I can speak to one example that Brent and I worked on together where the first spouse passed, okay? So husband passed away. And to make things easy, keep things easy while he was living, he traditionally bought real estate just in his name, right? Not in a joint name between him and his wife, okay? So when he passed with no plan whatsoever, again, Tennessee law got to decide who got his stuff, right? In his case, he was married, had 3 children, right? But Tennessee law doesn't say when you pass that your surviving spouse gets all your stuff. They don't get all your assets, okay? Tennessee law says that a surviving spouse gets a third or a child share, whichever is greater, okay? So in this case, this gentleman who had a lot of real estate that, again, just for ease of purchasing things, just bought in his name, did not go off to his spouse, okay? His spouse got a third of that real estate, and his children split the other 2/3, right? So not what we believe he would have intended to do, but since he did no plan, right, he didn't get to make that decision, okay? So no plan versus, let's call it just having a basic plan, right? What's a basic plan? When I say basic plan, I mean, what if you've just got a will that says where your things go when you pass, okay? That certainly is a lot better, right? You get to decide. You make the decision, right? You decide who inherits your assets, who those people are, okay? What that structure is. We'll talk about structure in a little more detail in just a second. But, right, you're the one making the decisions about who gets to inherit your stuff. You also get to decide who's in charge of that process, right? When you have a will under Tennessee law, you pick what's called a personal representative. Sometimes it's called an executor in different states. But, right, you get to decide who's in charge of that process to decide who gets to get your things to where they need to go upon your passing, okay? So having at least some type of plan, as basic as it may be, lets you be the one in charge as opposed to Tennessee by default deciding what happens, right? From there, even with the most basic plan, you also get to decide what that structure is for who inherits from you, okay? So I know Rachel did a great job talking about who inherits, protecting the farm, protecting your assets and things like that. And through even the most basic plan, Okay, you get to decide what that structure is that, based on how you do it, could provide more protection for those people who inherit your assets down the road. Okay, so starting there, and I stayed off the board as long as I could. I like to draw, as Brent can attest. But just throwing, I'll call it, two options at you. Okay, one being the most basic. One could say that if the beneficiary you want to leave assets to is old enough, if they're over 18 years of age, you could just say, here you go. You get what you get, what we'll call outright free trust. Okay? If you have no plan, if Tennessee law dictates who gets your stuff, this is what happens. But also you could have a will that says, hey, when I pass, here's who I want to leave stuff to, here you go. Since you're legally old enough to own stuff, good luck to you, right? But issues I would suggest to you with this, just to compare to what we otherwise can do, okay, for protection for the farm and assets and other things that we want to leave to children and other individuals, okay? What we'll typically suggest instead, because under option one, right, what you leave to somebody, it's their stuff. Just like it's your stuff, it's their stuff, for all the good and all the bad, okay? And when somebody owns something in their individual name, okay, if they get in a car wreck and they do something to get sued, ignoring insurance for the moment, but if they get sued, hypothetically, a creditor can come after what you own, right? And so your assets that you own individually or what you leave to a child directly, if they run into legal trouble, right, could be susceptible to that lawsuit, okay? What you leave to the child directly, if that child is married, they decide to take that inheritance and commingle it with their spouse, and then thereafter they go through divorce, okay? Well, if they make it marital property, it's marital property for all purposes going forward, which includes, if they happen to go through divorce, half of it's going right outside of the family, okay? In high level, when a person passes away, if they're worth too much, if net worth is over a certain threshold, the federal government would like to tax them with what's called federal estate tax, okay? And what we leave to a child directly, again, it's their stuff. So when they pass, it's part of their calculation, right, to see if federal estate tax should be paid. So what we'll typically suggest as far as how we leave things to a child or leave things to an individual is instead provide that whatever they receive is designed to go into a separate trust that's just for that beneficiary. And by default, if they wanted to, that trust can stay in place for that beneficiary's entire lifetime. Okay, it can stay in place for their entire life. Okay? We'll typically provide that that beneficiary can get distributions. Some of the magic buzzwords you'll see are for their health, education, maintenance, or support, right? But even if you tell me that, hey, this beneficiary, this child that I want to leave things to, I've got confidence in them that they can handle their own business, right? They're mature enough to handle the assets they inherit. I'm not worried about them wasting what they receive and things like that. What we'll do under option two, even though these assets are technically in a trust that you create for them, okay, what we can do is let the child be in charge. Typically, we'll condition the ability for them to control this trust on them being over a certain age, okay? But since this trust, right, was created by you, right, you're the one who created this trust for them, put the farm, put the assets, put the whatever it may be, the assets you want to leave to that child in this trust. Even though they've got complete control, to invest and manage that asset however they see fit, because you are the one who created this trust for somebody else, if that child ever runs into any legal issues where they get sued personally, get sued individually, creditors cannot touch what's in that trust, right? Because somebody else created that trust for the child, for the beneficiary. All right, this is somebody else's stuff in trust for somebody else. And again, even though they have complete control, creditors that sue them individually cannot touch what's inside. Okay? If it's in the trust, that means it's not being commingled with assets of a spouse. So we don't have to worry about a divorce ever touching this inheritance that you've left there for that child. Again, because this is still technically your stuff in trust for them. Okay? And whatever this trust might be worth when the child passes, again, because it's your stuff still, technically not their stuff, for part of their equation, right, to see if federal estate tax should be payable, this isn't included. Right? That's not part of it because, again, it's still your stuff in trust for them. Right? So this is one area where we'll typically push folks to give the child the opportunity to keep that inheritance protected. Inside the trust, they can do whatever they want to do. Right? They can keep the farm, keep the asset, keep it inside of the structure, sell the asset, buy a new asset. They can manage things inside the trust however they see fit. But again, big picture, big thought to have in your mind before we go to what we go to next. Since this trust was created by somebody else, for somebody else, they can have control and keep things protected. So starting there, or getting there, talking about how through even the most basic plan, we can leave things to a child, to a beneficiary, and keep them protected from life, if you will. Any questions on that so far? And I don't know if I'm supposed to ask any questions at any point, but any questions on that part so far before we jump into talking about the difference for you, for your stuff, all right, the difference in just a will-based plan, if you will, versus you putting a trust in place now, and the benefits you can get from that. Any questions so far about inheritance? Yes, sir.
So your parents give you a farm in a trust, 2025. They go to the nursing home, 26. Their funds are half of what the nursing home costs. Where are they gonna get the other? Can they go after that trust within a 5-year period, or what?
So issues you'd have there. So right, I would say at the moment, but let me talk about what you're asking. So the question is, you're talking about qualifying, I'll say, for nursing home care and how this affects that. At the moment, think about this as, hey, what happens when I pass? Right? If I pass away, what my will says happens. Or when I pass and I have a trust in place, what happens then? But, right, there certainly is planning around trying to create a trust now for somebody else and trying to qualify for Medicaid and for TennCare. I would say something like that, right? You put this trust in place now for somebody else, put your assets inside, and if you tried to apply, right, for TennCare next year, they're right. They're going to look back and see, well, hey, within the past 5 years, you made this gift. And they've got a calculation, a formula to say, well, hey, for the next, however long, you're not going to be qualified, right? So you can't get TennCare benefits. And if you've given it away, you also don't have anything to take care of yourself with, right? So hopefully there's some type of plan, agreement, structure, right, where the kids who now have your stuff will take care of mom and dad. But I've had instances where I've gotten involved on the back end. And that relationship with mom and dad wasn't what it was when this was first set up. And they, were not in the best spot, right? So the kids weren't going to agree, to take care of mom and dad with what had been given to them previously. Yeah. Yes, ma'am.
So, I passed away, I have a trust for my child. 6 months after I passed away, in the trust was $1 million bond. He don't want it. He wants to liquidate the trust. Can he do it that quick, and what are the tax implications?
Sure. So as far as how soon you could do something, we'll get into that in just a second as far as, hey, how is this trust created? Okay? Is this trust created under a will that you have, right, where you've got to go through probate and it takes time to get there? Or is it created through a trust that you put in place now for yourself that turns into a trust for your son when you pass, which could happen a lot faster, right? But once we get to this point, right, you're able to sell things just like you could if it was, sitting in your name, right? Process for once it's in the trust and it's established and being able to sell it, right, that can happen right away.
But it does depend if you give them authority in the trust.
What
Sure.
are the
You could
tax
restrict it.
implications?
Yes, ma'am.
Still $1 million bond, but who pays the tax? I know we're going to get taxes out of it somehow.
Maybe. So we'll talk about in a second, as far as high level when a person passes and they own an asset, whether it be a farm, whether it be stocks, whether it be a business, or whatever it may be. There's what's called a cost basis step up for when you inherit something, right? So you get that cost basis step up. And so depending on how much time there is, I'd say between the time it was inherited versus when it was sold, maybe. There may not be any tax, if it hasn't appreciated that much. But great question. Great question. Yeah. Any other questions before we jump? Yes, sir.
So when you go say you're gonna do a trust, you need to go have everything approved at that date. Is that what you're saying?
So I would say at this point when we'll call it parent passes, right? And the parent passes and now we need to establish what is the cost basis for that asset that now the child has received. That could be potentially the opportune time to get that appraisal just so you know, right, what you're dealing with going forward. Because it may be some of these assets, right, it could be a farm where, hey, if I sell it in the future, that's important. Or it could be where it's equipment or it's something else that I can depreciate, right, that I've got this high cost basis now to work against for accounting purposes going forward. So, right, there can absolutely be reasons when a person passes to get those valuations done, right, to see what you're working with going forward. Yeah. Yes, ma'am.
In correlation with that, you can't use the tax receipts and what's showing on your farm records that are at tax assessment.
You've got and potentially competing interests for yourself, really, when it comes to that.
Before you answer them, sorry. Coffee County has no idea what the question is.
Oh, I'm sorry. So question now, right, talking about cost basis. when a person passes, can you use the tax assessor values, right, to use that as your cost basis? It depends, is what I would answer, and it would depend on kind of what you're shooting for, right? So typically, I don't know if this is the case in every instance, but typically that tax assessor value is likely lower than what you really think it's worth, okay? So if you just take that and use that as your tax cost basis, then you might have shot yourself in the foot if you got an appraisal that said it was worth potentially something more, right? That means you could have sold it and paid less tax in the future or had that higher cost basis to depreciate against going forward. So not to say you couldn't use a tax appraised value for the property, but it may be more beneficial to get an actual appraisal that would give you a higher value, a higher cost basis to
So in
use.
the tax appraisal, when you get an appraiser, is it gonna be the green base appraised at green belt value?
I would say, not for that. I would say for the tax appraised value, they're going to look at, if you sold this property, right, which is like, it's certainly going to be more than what,
That's a difference.
100%. Yes, ma'am.
But generally, if you're passing it, you want a higher value on that property.
Sure.
If you're going to sell something, you want that basis to be higher than lower.
You got it.
Ain't nobody gonna sell it.
Hopefully. Except for that 70% on that statistic, right?
There you go. So this is, right, thinking about that, this is not only flexibility. If we wanted to sell it, we could, but also we've got protection that, hey, if stuff should happen in the future that we didn't anticipate, right, a car wreck, a lawsuit, a divorce, whatever it may be, we don't have to sell it, right, in those type of instances because we've got this protection built in to protect the farm assets going forward from instances we didn't anticipate. Okay? So that is, again, started with, hey, differences in no plan versus, we'll call it at least a little bit of a plan. This is saying, well, how do we have children, beneficiaries inherit once we pass, right? Now we'll kind of walk into, if there are not any other questions at this point, what's the difference in a will versus a trust now, okay? And then what types of trust options are out there?
Can you talk about the left-hand option, if there are more than one child involved, so if there's more than one heir?
Sure.
I think that is,
No, you got it. So what you'll see on the left side, so the left hand talking about just giving it to them outright, right? I mean, having this trust in place where you lay out what the structure is going to be. You lay out who's going to be in charge, right? You lay out, well, hey, if somebody wants to get out, somebody wants to sell their interest in the property, potentially creating what we'll call these rights of first refusal, or otherwise, just having some control about how you think that farm should be managed, or that property, that asset be managed, right? Having it in a structure that you put in place, can certainly, I would say, protect it from what you want to happen in the future versus what I erased that said, hey, well, it's yours, good luck to you, where you can't really put any restrictions or restraint or direction, right, on what that inheritance looks like. So certainly another benefit, right, to that. How you leave things to people can make a difference, without a doubt. So let's talk about the differences, again, in having, we'll call it at least a basic plan, but then maybe something we'll call more advanced, or reasons you would consider not just having, we'll call it a will-based plan, but potentially putting a trust in place now for benefits for yourself, but then also to make things easier on the next generation once you do pass away. Okay? So one thing I'll say that I didn't say yet, but what I just had up, right, where we're talking about these trusts created for children, individuals down the road. Okay? You don't have to have a trust in place right now to accomplish that in the future. Okay? It could be that you just have a will that says, hey, when I pass away, that's when I want this trust to be created for my kids. All right? So your will can end up being that trust document. Okay? At the end of the day, protection for individuals, children, all that down the road, we can get to the same answer under a will-based plan or a trust you put in place now. Right? It's just going to be different how we get there, what you can protect against and accomplish in the meantime. Right? So with the will approach, the pro for that type of plan, I would say that it's a little bit simpler for you right now. Okay? You'll continue to own your stuff just like you currently do. Right? Your real estate will stay in your individual names. Your other assets will stay in your individual names. So it's a little bit simpler for you, what we'll call on the front end. Okay? Because of that, though, right, because of that, to get your will effective, get it to who you want to get your stuff when you pass, your will is really not your will until the judge says so. Okay? So probate is a necessity to get your will effective and get things transferred to who gets your assets when you pass. Okay, probate is all about transferring those assets to who gets those when you pass. Okay, and with the will approach, again, you continue to own your things in your individual name. With the trust approach, meaning you put a trust in place now, okay, that says, we'll talk this through in a second, but a trust that's for your benefit, okay, but a trust you put in place now, we're going to put stuff inside the trust, right? We're going to transfer your real estate inside of the trust. We're going to transfer your investments inside the trust, okay? And because we put stuff inside the trust now, that means you're not going to own anything in your individual name when you pass. It has to go through probate, right? It's already in the trust. And the trust never passes away. It just says, well, here's what happens next, right? Here's who the beneficiaries are now, things like that. So in general, having a trust-based plan versus what we'll call a will-based plan is that we can make things easier for those on the back end that inherit from us because they don't have to mess with people like me and go through the courts, right? The trust just says, well, here's where we go. Here's who gets the assets. Here's who's in charge, things like that. Okay, so in general, any trust can do that for us, make things easier on the back end, and avoid what's called probate, right? Another, in general, benefit of the trust approach versus the will approach would be privacy, both for you now and for you later, right? So when I say privacy now, you know, people being nosy, right? Trying to look up, well, what do they own? What real estate do they have? Where's their farm at? What do they pay? What's it worth? Right? When you own it individually, like you would under the will approach, it's really easy to go to the property assessor's website, you know, type your name in and figure out what you got, where you got it, and things like that, right? With the trust-based plan, we'll often suggest to clients to not use your name as part of the name of the trust. You can call the trust anything in the world you want to. And because we do that, once you put your real estate inside, if anybody types your name to the property assessor's website, nothing shows up. Okay, so more privacy now for people being nosy, trying to see what you own from a real estate perspective. Also, I'll call it more privacy on the back end. Probate, again, which is required with the will approach, is a public record process. So anybody could go to the courthouse and say, well, hey, I want to see what so-and-so did with their stuff, right? Who inherited, what's the structure, who's in charge, things like that, and they could get a copy of your will and see those things. With the trust approach, again, a big goal is that we're not going to go through probate, so that document's never going to be disclosed. People will not get to see, you know, who inherits and who's in charge and things like that. With the trust approach, we'll still do what I'll call a just-in-case will, often called a pour-over will, that says if somehow, some way we missed something, if we forgot to put it in the trust, that pour-over will is designed to catch that asset through probate and send it to the trust. All right, but that pour-over will, it has no details about who's involved, who inherits, any of those things. It just says, well, hey, send it to the trust. Okay, so any trust can help you do that. Any trust can give you privacy. Any trust can help you avoid probate. Okay, but in Tennessee, we are, I'll call it super progressive from a trust law perspective. Okay, we've got options here that don't exist in a lot of other states that in addition to avoiding probate, in addition to giving us privacy, right, can also help us out in other ways. Okay, so the first trust, let me throw at you to give you a little detail on how it works. It is for married couples, right, and it is focused on capital gains tax avoidance down the road, okay, in case something needed to be sold once that first spouse passed. Or, again, if we've got equipment and other assets in the trust, getting a higher cost basis than otherwise we would receive to fully depreciate those assets again. Okay, so to show you what I mean, show you how that works, let me give you an example. Let's say that we've got a farm, or we've got equipment, or we've got investments, whatever it may be. Let me make my math easy. Let's say we've got something that has a value of $1 million. Okay, a fair market value of $1 million. All right, and let's say that this could be real estate. Let's say this is a piece of real estate that we bought a long time ago for $400,000, and over time it appreciated to be worth that $1 million. Okay, so $400,000, that's your cost basis. Right, so if you sold it while both spouses are living, you would typically pay capital gains tax on the difference in what you sold it for and what you got in it. Right, so in this example, we've got $600,000 of gain to pay capital gains tax on if we sold the property. Okay, in our example, let's say again this is a married couple that own this property in joint name. What the IRS would say is that each spouse put in half. Okay, each spouse contributed half of that initial purchase price, half of that cost basis. Okay, and under current law, when a person passes away, the cost basis they have in that asset when they pass gets an adjustment. Okay, this happens automatically. We're not in the trust yet. This is just how things work under the tax code. Right? When a person passes away, the cost basis they have in that asset when they pass gets an adjustment, gets what's called a step up in cost basis to whatever their interest in the asset is worth upon their date of passing. Okay, so in our example, again, property's worth $1 million, cost basis, original cost basis of $400,000. The first spouse passes away. His or her piece of that cost basis is what gets that adjustment up to what his or her one half is worth. All right, so in our example, the whole thing's worth $1 million. That means that each spouse's one half piece is worth $500,000. So when the first spouse passes, his or her piece of the cost basis gets stepped up to $500,000. The surviving spouse gets this stepped up piece of cost basis added to his or her original portion of the cost basis. So add those two together, the surviving spouse now has a cost basis of $700,000. Okay, so again, not in a trust yet. This is what would happen automatically just for married couples that own property in joint name. But now the tax fact for that surviving spouse. Let's say the surviving spouse decides to sell that property. Okay, or if it's equipment, depreciate that property again. With that higher cost basis, right, if we sold it, we've only got $300,000 gain to potentially pick capital gains tax on. Questions about that so far before I jump you into a
That's
trust?
a big thing that you have to make sure your accountant's aware of that. So they don't, naturally, they don't always grab that, right? So if, a lot of times if you don't get the appraisals on that equipment, that barns and stuff you depreciated out, you don't naturally get that unless you are focused on that. It gets missed a lot. We rarely ever see it done correctly.
Sure.
So that's just naturally before you do a trust.
That's it. So yeah, not in a trust yet. This is how things normally happen under the tax code. Okay. So the first trust, let me throw at you, is what's called a Tennessee Community Property Trust. All right, a Tennessee Community Property Trust. Okay. Again, this is a married couple trust option, right? But with any trust you put in place during your lifetime, you've got at least 3 roles. You've got what's called a grantor. Or grantors, that's your trust creator. That's the one who they're putting their assets inside the trust. You've got what's called a trustee. Or trustees, right? That's who's in charge of what's going on inside the trust. And then you've got what's called a beneficiary or beneficiaries, right? Who's this stuff in the trust for, right? So again, married couple trust, we'll say husband and wife in this example. So under this one, we'll typically have both spouses as our trust creators, both spouses as our trustees, and both spouses as our beneficiaries, right? So not changing the dynamic of anything typically whatsoever, right? This type of trust can help us avoid probate. This type of trust can give us privacy like we discussed. But its special benefit, what it does, different than any other type of trust, okay, is protect the surviving spouse from capital gains once that first spouse passes away. Okay, so the way it works, what it does, its special feature, take our same hypothetical, asset worth $1 million, cost basis of $400,000. Okay, but if we've got this asset, this farm, this equipment, these investments owned by a Tennessee Community Property Trust, instead of having those assets in our joint name, okay, when the first spouse passes, not only does the first deceased spouse's one half get that step up, okay, but the surviving spouse's one half also gets that step up. It's now the surviving spouse would have a full fair market value cost basis. So if at that point, surviving spouse decided, hey, I do need to sell this asset, I do need to sell this real estate, I do need to sell these investments, or I do need to sell this equipment, the surviving spouse has the flexibility that he or she could do so with no capital gains tax to pay whatsoever.
You can also depreciate your equipment
Right.
again. Depreciate the barns again. So if you've already depreciated this out, it steps up to the current value.
All the way, full value.
It's a great way to generate extra income tax-free.
That's right.
Because now that depreciation's coming, you got that rent, or whatever income you have, that's coming off against it.
You got it. This has been around under Tennessee law since 2010. Okay, and this is Tennessee's way to get on a level playing field with states like California, Texas, Arizona, that are by default what are called community property states. And for some reason, the tax code says for community property, when that first spouse passes, full step up for both halves. Okay, so in those 9 states, this happens automatically. They don't need some special type of trust. All right, but Tennessee is one of 5 states through statute, through law, to let married couples opt into the special tax feature that community property receives. Let me stop there. Questions about that one? Questions about it, how it operates, or how it works?
Did you call the number 1 under the roles? I know
Oh.
trustees too. and-
Grantor.
Grantors, yes, ma'am. Grantors is what I'll call it. Sometimes practitioners will call it settlors or trustors, but the creator, the one who forms the trust. Good talk.
Is this a revocable or irrevocable?
Great question. So while both are living, I'll typically draft this type of trust to be a revocable, amendable trust. So you can change anything you want to change, take things out, do whatever you want to do. Okay? For protection reasons that I'll get to a little bit in just a second, for best structuring things for federal and state tax reasons going forward, and frankly to best protect things that, hey, what the couple agreed to would happen to an extent when the surviving spouse passes, as far as flow of assets and things like that, I'll typically draft this trust that once that first spouse passes, it becomes an irrevocable trust, okay, for, I'll call it good reasons. Practically, even with that, typically the surviving spouse is the sole trustee, is the sole beneficiary, so it's still all for you and you're in charge. We just say the right things on paper to give you some protection that we otherwise would not get if it did not become irrevocable. But while both spouses are living right, it is a revocable, amendable trust. Any other questions on that one at the moment?
Tennessee is one of 5 states.
Tennessee. So Alaska was the first. South Dakota also has this. Tennessee in 2010, Florida in 2021, and Kentucky more recently have put in place these types of trusts to take advantage of this. This type of trust, you don't have to live here to utilize this type of trust. You don't have to have assets in Tennessee to utilize this type of trust. The only connection, the requirement is that while both spouses are living, we need at least one what's called qualified trustee. A qualified trustee is a Tennessee resident or a corporate trust company qualified to do business here, okay? And that requirement, again, only exists while both spouses are alive. So if the first spouse passed and the surviving spouse wanted to move out of state or go somewhere else, that's fine, right? We've gotten our special benefit once that first spouse passed.
You can put out-of-state
Yes,
property into that also.
You can. I've formed these before for people that have never set foot in Tennessee, have nothing in Tennessee. When we do that, we'll typically have what we'll call a token Tennessee co-trustee that serves with both spouses while they're both living. It's just there to meet the statutory requirement, if you will. And then once that first spouse passes, we say goodbye to the Tennessee trustee because it's no longer needed. But right, it can own stuff out of state. Yep. Yes, sir.
There's also a grantor trust.
Yep. So,
Both when it's revocable and irrevocable, both times.
so while it's revocable by default, so the question is in non-tax terms, who pays the tax, right? What's the tax ID for this trust? Since it is revocable, right, by default, it's automatically a grantor trust, and therefore this trust would use you, the grantor's, your social security numbers as its tax ID, so it's real simple, right? All the income shows up under 1040, just like it does now. When it becomes irrevocable, all right, I'll give the surviving spouse what's called a grantor trust power to use the surviving grantor's social. I'm getting in the weeds on your hard here. If we did some proactive planning within the trust and we split things into 2 separate trusts for federal and state tax reasons, half the trust would use the surviving spouse's social, half the trust would not. It would be a separate trust and get its own tax ID. So I know that's pushing it a little bit in the weeds, but no, great question. Yeah. Any other questions on this one for the moment?
What would happen if both of the spouses, both husband and wife were in an accident and killed or something?
You got it. So the benefit here compared to other options or no planning or basic planning or any of that, the benefit here is all about between the first spouse passing and the surviving spouse passing. Okay, when we get that high cost basis step up. When the surviving spouse passes here, if you don't do any estate planning at all, if you've got other types of trust, when things get to the kids, are typically going to look the same, that we'll get that cost basis step up at that point. Okay, this one's not different than other options in that realm. It's just when the first spouse passes, this does something that's different than no other trust does. Yeah, good question. The question there was, hey, what happens when the surviving spouse passes from a tax perspective here, versus other options? So, yeah, sorry. Yes, sir.
You already have a trust and you have your name in the trust. Can you change the trust name to take your name out of the trust? Or you have to start all over from
So,
scratch?
great question. So with this type of trust, I would say, and I'll tell you, for example, we'll have a lot of folks, everybody that moves here from California, already has a trust. Okay, because probate in California, from what I understand, is terrible, is so much worse than it is in Tennessee. Okay, Tennessee, it's not the worst thing ever, but it still takes time and costs money, even in the best case. But to answer your question, right, as far as, it depends on what you're looking to do, right? Hey, I'm not worried about privacy. I just want to make sure that I get the benefit that this trust can provide. It will take an old trust that may have your name, okay, and we can amend to restate it and convert it to a Tennessee Community Property Trust, okay, to get the tax benefit. But unless we start over, it's always going to have that same trust name, potentially. I mean, we could update the name, but then we still got to retitle all the properties.
Well, that's what I'm saying,
Yeah.
because then you got to retitle
You do.
everything, and then
Yep.
you got to change all the records at the FSA
Sure.
office, and it becomes a nightmare.
So if you wanted to go for the privacy angle as well, right, you're in essence going to start over. If the privacy is not as important to you, you could we'll call it keep the same trust, just amend and restate it and make it convert it to a Tennessee Community Property Trust so that you get the tax benefit, but technically it's still, from an ownership perspective, still the same trust. You wouldn't have to retitle assets in that area. So protection here is defined as capital gains tax down the road. Right? Protection here is all about taxes. Okay? Protection here, though, is not, well, hey, what if somebody can sue me and tries to come after my stuff? That's not what this is geared for. Okay? That's not what this is focused on. Okay? To kind of lead you into the next trust, typically the thought everywhere across the country has been that you cannot form a trust for yourself, take your own stuff, put it in a trust that you're a beneficiary of, and protect those assets in case you got sued. Okay? Typically that's been the rule all across the country, right? Remember with me where we started, we talked about, hey, what if I form a trust for my child, okay, a trust for somebody else, right? I can let them be in charge, and you do get protection because, again, that was somebody else's stuff in trust for somebody else, okay? But if you put stuff in trust for yourself, typically you don't get protection. And that would be the case here, right? This is all about taxes, okay? If you got sued, somebody could come after what you've got inside of this trust, just the same as if there was no trust at all, okay? So if this makes sense because we've got good tax facts, we have assets worth more than what our cost basis is, right? We're making sure we've got, we'll call it sufficient umbrella coverage, liability insurance, things like that to protect against an accident, lawsuit, things like that. Right? Protection here is all about taxes, okay? Again, typically the thought, the rules across the country, you can't form a trust for yourself and protect assets, okay? But Tennessee is one of a number of states now that do let people do that. Okay, do let people create what we'll call domestic asset protection trust, where you can form a trust that's for yourself, put your own assets in that trust, and if you get sued, absent some certain factors we'll talk about in a second, creditors cannot touch your stuff. Right? Creditors cannot touch your assets. Okay, so that trust option. That trust option is what's called a Tennessee Investment Services Trust. Right? A Tennessee Investment Services Trust. Nothing magic in the name. That's just what Tennessee decided to call their version of an asset protection trust. Okay? This one's actually our oldest. This one's been around under Tennessee law since 2007. Okay, but again, it's designed to do exactly what I just told you. Most states will not let you do, but form a trust that is for yourself to protect those assets in case you got sued. Okay, so any type of trust, again, same type of players. You got what's called a grantor. You've got what's called a trustee. You've got what's called a beneficiary or beneficiaries, right? Who the stuff is for. We'll go with the same context of talking about a married couple just to show you how this one is similar, how this one's different than the first trust. Okay, this trust option, you don't have to be married to utilize. Okay, this can be formed by single individuals as well. Okay. This type of trust, and going back to the question you had a second ago as far as revocable versus irrevocable, this type of trust is different in that upon inception, it is technically an irrevocable trust. Okay? Words should mean what they sound like, right? Irrevocable sounds like it's locked in, I can't make changes, can't get stuff out, things like that. As we'll kind of walk through in a second, there's a whole lot more flexibility than you would anticipate with a trust that is technically irrevocable and still get the benefit that it's designed to provide. Okay? So the way this one works structurally, what it looks like, and again, in our context, we're going to talk about a husband and wife, but again, this can be formed by single individuals as well. Typically, we'll structure the trust that both spouses are beneficiaries of the trust. Okay? But the statute says, to get the protection I'm going to walk you through next that this type of trust can provide, the statute says that if you're a grantor, right, if you create a Tennessee Investment Services Trust, you cannot technically, and I'll stress the word technically, but you cannot technically be in charge as a trustee. Okay, so with this type of trust, hypothetically, we could make it like the community property trust and have both spouses be grantors. But if we do that, that means neither spouse could be a trustee. All right, so what we'll typically do in the married couple context, we'll have one spouse be our grantor spouse. We'll have the other spouse be our trustee spouse, so that it's still y'all. It's still y'all are the ones involved handling your stuff through the trust. Okay? So the way this type of trust works, again, the grantor is the one who forms the trust. They're the ones who put the stuff inside the trust. Right? When the grantor does so, he or she signs what's called a qualified affidavit. That affidavit says such things as I'm not trying to defraud any creditors. I'm not planning on filing bankruptcy. This doesn't make me insolvent, stuff like that. Okay? Put the asset in the trust, sign the affidavit, and provided a creditor cannot come along within the next 18 months and prove to a judge by clear and convincing evidence that, hey, judge, I am the reason. Me. I'm the reason the grantor formed this trust in the first place. Okay? I was knocking on the door, said, pay me my money. And the next day, they formed this trust to get around me specifically. Okay? Absent there being that creditor that is already there, that comes along and makes that proof within 18 months after you put the assets inside the trust, if you get sued individually for anything you can think of thereafter, creditors cannot touch what's inside of that trust. Okay? Whether that be real estate, whether that be investments, whether that be equipment, whatever that asset might be. Okay? Again, absent there being this pre-existing creditor that already is there and can make that proof that they're the reason you put the asset in the trust, if you get sued for an accident or something you do intentionally in the future, creditors cannot touch what's inside of that trust. Okay, so more so focused here on protecting our assets in case something happened down the road that we didn't foresee coming along. Okay? Questions on that so far before I give you some more color on the word irrevocable, what that means in this context? All right, so with any trust you put in place on the front end, you're going to say what you think makes sense, right? You're going to say, well, here's who's going to be involved, here's what's going to happen down the road, all those type of things, which is going to include, right, who the trustees are, right? Who's the initial trustee? If something happens to that initial trustee, who would be what I'll call successor trustee number one? Who would be successor trustee number two? So on and so forth, okay? Even though the grantor cannot serve in that capacity, they cannot serve as trustee, the statute does permit the grantor to remove and replace the trustee at any point in time for any reason whatsoever. Okay, so let's say that the trustee spouse happened to pass first. Now the grantor has a non-spouse who's serving as their trustee, which may be a child, maybe a friend, maybe an advisor, somebody like that. But let's say they're just not doing what they want to do, and they're not listening to what they want to say, and they want to get somebody different. No problem, right? The grantor can remove and replace that trustee at any point in time for any reason whatsoever. Right? So even though the grantor can't serve in that capacity and technically be the one in charge, they get to decide who does. They can always get rid of that person if it turns out it's not working. Another bit of flexibility you can have in this type of trust is the grantor can serve as what's called the investment advisor for the trust. And the way we structure these trusts, an asset cannot be bought or sold that's in the trust without getting direction and consent from the investment advisor. Right? So technically somebody else's trustee. Technically, the trustee is who holds title to what's inside the trust. They're the ones who would sign the deed if the property needed to be sold, but they don't have the authority, right, to sign that deed, to sell the farm until they get consent from the investment advisor. Okay.
So by doing that, of course, you're setting it up to where, yeah, you've named a trustee, but you still effectively have control of everything. And like you kind of mentioned that earlier too, just to reiterate, like if you want to fire the trustee for any reason, it's you don't like the color shoes they're wearing, you can get rid of them. You don't need cause. So in effect, you still control every part of your asset.
You got it. Another piece of flexibility here, right? In our example, we've got both spouses as our beneficiaries of the trust. Typically, we'll say that they can get distributions for their, again, magic buzzwords, health, education, maintenance, or support. But for whatever reason, right, you decide, well, I don't want this asset in the trust any longer. Okay, it's not as if, again, it's locked inside the trust. It's just, we'll call it husband and wife, talk to wife, and they decide, well, hey, I want to take this asset out of the trust, and you take the asset out of the trust. Okay, whether it be because an asset was sold and now you've got cash that you want to do something different with, whatever it may be, you can still get stuff out of the trust. Okay, it's not, we'll call it potentially a revocation of the trust like we talked about up here, but potentially maybe it's just a principal distribution, and that asset comes out into the beneficiaries, but they can do something different with it if they needed to, if it made sense to down the road.
So the trust exists, but all the money's out, right?
Sure.
So your farm is out of the trust. If you don't like how it's working, just pull it out.
You got it.
There's no money in it, so it's irrevocable, but it's not really.
There's nothing it controls. You got it. And then any type of trust, again, typically has what I'll call willish provisions, estate planning provisions that say, well, hey, here's what happens next if something happens to this person, so on and so forth. So, for example, let's say, hey, the trust is for the benefit of both spouses. We say that, hey, if the first spouse passes, it continues on for the benefit of the surviving spouse. And then when the surviving spouse passes, and for our example, let's say that the couple have 2 kids, okay? And so we say, hey, when the surviving spouse passes, we're going to put half the assets in a trust for the benefit of child 1 and half the assets in trust for the benefit of child 2, okay? And let's say that we set these trusts up by default where, hey, if the child wants to keep things in trust for their lifetime, they can. Let's say that we decided, hey, we're going to let the child be in charge of their bucket, let them be what we'll call the sole trustee of their trust if they've hit age, I'm making stuff up, age 30, right? If they've hit age 30, once we both pass, they can be in charge of their bucket, okay? But let's say life happens, right? Life happens, things change. Let's say down the road, after you put the trust in place, let's say a child got married to somebody that you can't stand, right? And you're worried that, hey, if that child gets control at age 30 once I'm gone, that spouse is going to make them do things I don't agree with. I don't like what I thought made sense back then any longer, okay? Even though the trust is irrevocable, we can give each spouse, and it would typically be the surviving spouse who would take that action, but we can give the surviving spouse what's called a limited power of appointment, right? Where if we need to make some updates down the road for how our kids inherit or what the structure might be for them, we can still make updates like that, even though technically it is an irrevocable trust, right? So even though it's irrevocable, we can still change who's in charge. We still get to control the decisions that get made by that trustee. We can still get stuff out as a principal distribution, and we can also change what happens down the road once we pass away.
Well, like
Okay.
you said, Carl, if you don't want them to sell the farm, you can put that in there. You can't
Absolutely.
sell this property.
Right.
You know?
Yes, ma'am.
Is this without the tax of the capital gain?
Great question. Great question. So this one's different based on our structure, okay, than the
Well,
first
you
one.
can't be the best of both.
They haven't created that yet. Give us some time, right? Give us some time. But you got it. With this one over here,
Carl, once they do 15 years of this, they get new trusts to sell, right? So then at that point, they'll have the improved trust covered.
there you got it. So right, remember with me with the community property trust, its special benefit was, hey, first spouse passes, full step up, right? All the way to fair market value. It didn't matter which spouse passed first. Either spouse, full step up, okay? This one, based on our structure, it does matter order of passing. So to answer your question, maybe, potentially, right? You would get the same benefits. So to walk you through what I mean by that, take our same numbers, assets in the trust worth $1 million, cost basis of $400,000, same tax facts as the first trust. But again, based on our structure, it does matter order of passing as far as cost basis step up goes. Okay? So the trustee spouse technically did not put anything inside the trust. Technically, the entire assets that go in the trust come from the grantor spouse. Okay, because of that, if the trustee spouse passes first, since he or she did not make a contribution to the trust, there is no cost basis step up whatsoever, right? It would still be whatever it was when it went in, if you will. When the grantor spouse passes, since he or she put everything that went inside that trust came from the grantor. When the grantor spouse passes, we get a full step up at that point. So this one,
Old person needs to be granted.
you got it. You got it.
No,
You got
it's the unhealthiest person. Probably,
There you go. You got it. So it's thinking that through.
I have a hypothetical question. Okay, you do this trust, and you were talking about, I mean, this was brought to our attention, and we've seen it happen. You leave your farm to a child.
Okay.
That child marries, and they've got children now. Can you, in a trust, leave it to heirs and assigns?
Yes, ma'am. So the question,
In case one of those, the child passes away.
Right.
His spouse is left, and then she remarries,
right.
and this guy's got, four.
Sure. Now you got it. So the question is, can you protect, I'll rephrase the question, can you protect that what you leave in trust stays within the family, right? Stays for your children and their children and so on and so forth, for descendants, right? I'll tell you, again, and I'll make this comment, for any trust we draft, any will we draft, it's your canvas, right? You tell us what you want it to say. I'll tell you 99% of the time exactly what you just said is what I see put in place, right? Where, hey, I leave assets in trust for my child passes, it goes to their children, right? We'll typically give the child flexibility to update the structure for their children and potentially also charity, right? But a lot of times the thought is that, hey, you started this, okay? So we're going to keep it within your line going forward, right? I can remember one instance that I won't forget where I met with a lady, and she had 2 sons and 2 daughters-in-law, and in her document, she said, well, hey, I want to, in essence, split things 4 ways, right? 25% to each son and each daughter-in-law. And so my question was, well, hey, what if they get divorced, right? Is that still what you want to do? And she said yes. I mean, I think she liked the daughter-in-laws more than she liked her own sons. That was the thought process she had. So, again, it's your canvas, but what you're thinking about is exactly how we lay it out almost every time. You got it.
One thing that capital gains as well, that John can do is if you have maybe one piece of property where the husband's a grantor and another piece of property where the wife's the grantor, then you're getting a basis, you're hedging your bets, right?
You got it.
So you get with one, not the other.
You got it. So if you've got one spouse, that is a lot older, you've got one spouse that's not in as good health as the other, then right, maybe it makes sense that, hey, it's more likely than not or almost a certainty that this spouse will pass first. So let's set them up all the same way, right? Let's have that spouse be the grantor spouse so we get the cost basis step up, right? But oftentimes we don't have that crystal ball, right? We don't know who's going to pass first. So exactly how Brandon's saying, with this type of trust, for other reasons I'll tell you about next, okay, we may have multiple ones of these. We may have, we'll call it property 1, farm 1, and trust 1. Then we may we'll call it farm 2 and trust 2. Okay, and this type of trust, in addition to all of that protection we've been talking about, can also let us silo assets off from one another, right? In case somebody slips and falls at property 1, with this type of trust, all that we've exposed is what's in that same trust as property 1. If we've got a separate trust, it's not exposed to what happened in that other trust. Okay, but to Brent's point, from a tax planning perspective, too.
That's another thing. It's important too for liability. If something happens in that property, that property is still subject to being sued over, right? So if something happens to you personally, if you're driving a car and you accidentally kill somebody, you don't own that property, so you're protected. But if someone's hunting in your land illegally and they somehow realize, you put some barbed wire somewhere and they find you at fault, they could get that property. So if you have separate trust, then you're separating that liability. Go ahead.
You got it.
What separate trust for each?
Yes, ma'am. Right. So it may be that you've got, and that's possible here. That's not possible here with the Community Property Trust. But with the Tennessee Investment Services Trust, right, you may have what we'll call Trust 1 that owns Property 1, Trust 2 that owns Property 2, Trust 3 that owns investment accounts, Trust 4 that owns primary home. Right? And because you have those separate trusts, they create separate silos where each property is separate from a liability perspective than the other trust or the other property.
But also to Tyler's point too, is it all follows on the Social Security number. So when you're doing your tax return, you're not having to do 50 trust tax returns, right? Because that's not practical for most people. So it's still falling in that one Social Security number for taxes, which makes this a possibility, right? Because if you got 30 trusts, I don't want to do 30 tax returns. You know, I don't do tax returns anyway. I'm not an accountant. But anyway, that's the thing.
No, you got it. You got it. So yeah, that one, again, two different types of trusts that can do a lot of the, we'll call it the same general benefits, right? Avoid probate, give you privacy, plan for the future, right? Plan for succession, plan for protection for children and descendants and things like that. Put parameters around how you want that farm or how you want that asset to be managed going forward. Both of these do that. It's just, hey, what do they do for me differently now, right? This one's all about tax protection once that first spouse passes.
Capital gains.
You got it. Protection here is all about, hey, well, what if I get sued? Or otherwise just want to separate liabilities between assets, between different properties, between other types of things. So different focuses, different benefits. Questions on those? Again, I know it's a lot to throw at you, but questions on really? No, ma'am. There's others out there for sure, right? There's certainly other types. You know, these are two of the most that we'll do. I'll call it for clients in Tennessee. These are what I'll often refer to as page one type of trust options, right, where we're focused on protection in some form or fashion. We're focused on avoiding probate. We're focused on privacy. If we're also worried about what we'll call federal estate tax, what that could look like in the future, there's certainly what I'll call it page two, where we're also looking at other trust options to get proactive, in that regard. I'm good. That's what I've got. Unless y'all have got questions here, that's everything.
Question from Coffee County. If you put an asset into a trust, do you still have ownership of that asset, again, for if you were applying for funding from a grant or something like that? So whenever you're applying for funding, you have to have ownership of that land in order to apply for funding for that property. So who has ownership, I guess, still?
Great question. No, it's still yours. And I would certainly say with this one, with it being a revocable trust, you could get it back anytime, right? I would think it would be looking at the rules and regulations specifically for this type of trust, since the Tennessee Investment Services Trust, since technically it's irrevocable, right? What are the rules, right? What do the rules say as far as how much control, ownership you have to be able to do that, right? In this context, it's oftentimes going to be, we'll call it both spouses, if it is a married couple. And just seeing what the rules are for that type of requirement, there. From a, thinking about this from different angles, from a, hey, what if I want to use that property for maybe different things, but use it as security for a loan or something like that. The trust will typically be drafted to give the trustee the authority, if you want them to use that trust or use that trust property as collateral, right? Or use it to secure loans or make guarantees and things along those lines. So, yeah, I'd say my anticipation would be, since this is revocable with the Community Property Trust, absolutely. With the Tennessee Investment Services Trust, since it's technically irrevocable, right, it may be just making sure within the rules that, hey, we've got the right people involved with the trust. Or otherwise, a lot of times, whether it be with banks or whether it be with government, things like that, oftentimes having conversations when maybe they're not as familiar with types of planning that we're doing can get you across the finish line and have things like that that'll still work.
And also, too, on our YouTube channel, there's a QR code there, too. Some of the other trusts that Jonathan talks about are in there as well. So if you do like the YouTube channel, McKay Wealth Advisory, or just click on that or the Facebook page, then you can see some of their stuff. So it'll be a lot of time. Yes?
What's the cost by the hour, by the document, by the total asset?
Amount of words? No. Yeah.
Is there any work that people can do? Is there a standard fee for this, or, that way they don't get sticker shock?
You got it. Great question. So I'll tell you, the process with us typically is that we'll meet and we'll, know a lot of what you talked about, Rachel, earlier, about, hey, knowing your stuff, right? Knowing what you got, knowing what it's worth, knowing what liabilities are out there. That's helpful to come prepared with, I'll call it a financial statement, that information. So we could talk about and kind of give our opinion if you want to know it, but hey, what can make sense for you based on your facts, okay? And so then it's typically walking through that and kind of developing what we think a plan would look like if we want to put something in place. And we've done this enough after we kind of talk through what we're going to do. We typically charge by the hour, but we can tell you where we're going to finish, right? Barring something completely unforeseen, right, that's out of the norm or just something that we didn't anticipate on the front end, we can tell you where we're going to finish from a cost perspective once we get into the details and talk through what you're looking to do.
People don't even, doing a wheel, they don't even know what they own. If they go to this, piece of paper,
Sure.
2 hours later, they think it's something else.
Sure. And I'll make this comment, and not to say that what other people do matter for anybody else, but we'll have these meetings with folks, and we'll talk about, again, a lot of what we talked about today, a few more things, but we'll talk about the differences in a will versus a trust and what you can accomplish, through a trust-based plan. Yes, sir. And probably, but I bet you within the past year, being with folks and talking about your options, maybe once or twice, I've had folks that decided to just put wills in place and not take advantage of the trust laws we've got in Tennessee just for what they can accomplish. Yes, sir. Sorry.
So if you have the Tennessee Investment Service Trust, and that protects your assets, then does that kind of replace an umbrella policy?
To an extent.
Or do you still need the umbrella policy?
You still would. I think Brent made a good comment earlier. You'd still want to have the insurance or some type of insurance because you don't want to lose the asset, right? Say that there is an accident on the property. So somebody slips and falls and they sue the owner. Well, the owner is the trust. So what that trust holds is exposed, right? So you still want insurance so the property doesn't lose itself to itself. But the protection, the peace of mind you certainly have now is, hey, if I do something personally, right, and they can come after you personally, whether I've got insurance or not, they still can't get to what's in the trust, even if that insurance was insufficient to protect against that lawsuit.
I will say though, if you have a trust, it's a lot of work. Because, not the trust, it's afterwards. You've got to register it with your bank, you've got to have a separate account, you've got to have it at the FSA office, it's like everything, and you go through and you have to give them that book and they make copies and.
You've been through that. So I would say, I'll give you a couple thoughts there. For one thing, I think it's easier when you're doing that while you're living versus having to do that, your heirs, your beneficiaries do that on the back end. I'll say our office, as much as we can do, like to quarterback that process. I'll tell you the first, because the trust we've talked about, if you don't put stuff inside, they're not going to do anything for you, right? So I remember when I first started practicing, meeting with some clients and working with the attorney I was working with then, I asked him the question. I said, after we had some clients put trust in place, I asked him, I said, hey, are clients consistent once they put a trust in place about funding the trust, putting assets inside? And I'll never forget, his comment was, they're absolutely consistent, they never do it, right? So it's almost like, hey, this is your first time, right, to put a trust in place, and now it's your job to figure out what the next steps are, which makes no sense, right? So our office, when we do put trust in place for clients, we certainly quarterback that process where if it's any real estate you have, we draft all the deeds. All you got to do is sign the deed. Any communications with the investment firm as far as what assets go in the trust now or what beneficiary designations just need to be updated, things like that. Right, we've got to make sure we do all those steps like we talked about on the front end to make things easier on the back end, but also to get the benefits that these can provide.
And you're absolutely right. If you don't do the work, you just wasted money.
Sure.
And so it is the thing that most people forget to do. And one good thing about John, their firm is a lot of firms in the past was give us a document and say, here you go. Well, you need to complete it. Right. You need to do the deeds. You need to change it. But like he said, too, it's a heck of a lot easier, and especially the more money you have, typically a lot of times the more it might cost when you die. If you kind of know what the set price is, I think there's some benefits to that. You know what it's going to cost versus, I was give Jonathan a hard time. Like, I think a lawyer's Bible is ability to pay. You don't see a lot of homeless people suing people, right? So the more money you have, the more a lot of times you get charged. So if you get a set price, it's usually a better deal. And we're not affiliated. We're friends, and we refer customers to their firm, but we don't get any compensation on that. So I'm just speaking direct on that.
I think a lot of people are scared of the word trust. Scared of the word, they put the stuff in there and they can't do anything with it.
Right.
I learned a lot tonight about how flexible it is.
Yeah, I'll tell you for what it's worth, this word right here, irrevocable, on my end of the table is a good thing, right? Because it means you're getting some benefit protection-wise from some different angles. So, right, I'm with you. I get that thought. comments I'll get a lot of times from people that maybe don't deal with it as often is, right, I'm giving them my stuff away, or I'm losing access, I'm losing control. But that's really not the case, right? From what we talked about tonight, that's really not the case whatsoever. Any other questions on all that? Again, I know it's a lot to throw at you.
Just for one quick second, I know we're almost up to go, but more about the will option that forms a trust upon death.
Yeah, so what that looks like, right, we started, or we close to where we started, is protection for children down the road, right? And trusts that could be formed when you pass, okay? And again, I'll make the same comment I made before. You don't have to have a trust now to get a trust later for children, okay? You could have a will that creates what we'll call a testamentary trust, that your will document ends up being the trust document, that it creates a structure, that what we've been talking about for protection for them, through the will, right? It's just, the difference is you'll see there, right, or hey, we're not getting the tax benefit we otherwise would get. We're not getting the protection we otherwise would get. And also we're having to deal with attorneys and courts and things like that on the back end to get that process in place and get those trusts funded. Right. Yes, ma'am. I do. Yes, ma'am.
And also on Thursday in our Manchester office, Jonathan's going to be back to talk with the cabinet extension office that evening. So at 8 a.m. on Thursday, we're at 202 Woodbury Highway, which is right by the rec center or Cracker Barrel in Manchester. It's a big house there. So if you do want to come, we're going to be there at 8 a.m.
Thanks, man. Thank you all. Thanks very much. Yeah. All right. Thank you.